Hello and welcome. Welcome to the Divergence series. I hope you guys are having a fantastic time coming to some unknown realizations. Well, we welcome you all, of course, and we welcome you especially to the truth and facts. And I surely hope that there is no one's wasting any time in reading the formally agreed affidavit and to get to into knowing the facts. Okay, so another amazing epic time that we are in. Yeah, so they call it the Christmas, whatever that is. And another year, another loop, and yeah, we have the same old. Yeah. The terrorist company masquerading as your loving, caring government. Maybe you guys know, maybe you don't. But yeah, that's what we are going to touch on this amazing segment here. The last one I did was about that lovely letter that I came that came to my viewing, which yeah, it is what it is. Then I received in the group a thing about the person that was talking about that. Well, it's jibber jabber all day long. So I decided that instead of going and focusing on the jib jabbers, we better go and dive in what is really the thing that is going on, and how can you tackle the remedy, and how you go about and do your thing. To know that all we have is fear and apprehension, because we don't know things and we think that, I didn't learn enough, so I don't know what is the truth. But the truth lies in one thing: the consent. Right? So if anything else, you need to see that consent is very much required. So stick to that, and you will see that your consent will pretty much do the job, like this mental, all the things that are not real per se, So with that in mind, let's go and dive in what I've brought to you guys today. I hope you're seeing my screen all right and everything is good. All things are working. What you have here is a lien. Okay, security by way of lien was done by Adrian James. And I wanted to bring this one because this one is very on point on this segment. So as you can see, when you go and read a lien, this is where you need to start. Okay, so this is the Exhibit A. Okay, this is where you should be starting when you're looking into a lien, and I will guide you through that. Okay, so here we have the material evidence of claim by Mr. Tudor Davies in the position of complaints investigation manager for HM Revenue and Customs, and also the respondent's correspondence by Adrian James. Okay, so let's dive into this one. This is where everything starts, and this is where we are able to pick up the claim. So this particular one is in the public, so you can find this on Security by Way of a Lien Facebook page. You can find this one in Freedom by way of an email, and Correct the Unlawful Legal System, which is all on Facebook, or you can download it as well in the Baron David Ward's website. Okay, so this is out in the public. Everyone should be having a look through what remedies we've already did. Yeah, many of us, what we are doing, our work, and I have something to show you as well that Adrian provided. But so far, let's go and keep to this one. Yeah. So MRC reply ID, yeah, processing complaints team. The date, so this was on the 9th of June of 2021. And this is what we have to work with, yeah? So, dear Mr. James, thank you for your emails on the 19th and 7th of June 2021 to our Chief Executive. I have been asked to reply on his behalf. I'm already laughing because I already know how funny this is. I am sorry that you are unhappy with the UK tax laws. Oh, are you then? Okay. Okay. The UK tax laws. How funny is this one, right? Oh, there are laws for this, right? How funny this is. Okay. You have stated that you are not obliged to pay any form of tax. I am afraid, you should be very afraid, you are mistaken in this belief. Oh, this is a belief then. Okay. So, he continues to say, your obligations as a taxpayer are laid down within the Taxes Management Act of 1970, specifically but not exclusively at Section 59B. No contractual agreement needs to exist between HMR Revenue and Customs and yourself in order for you to be liable to pay income tax. Wow, how amazing this is, right? So HM Revenue and Customs do not accept any of the conditions contained within your letter. The obligation to pay income tax is set out in statute law. Okay, so we have amazing words here to look, right? So it's the statute law, it's the UK tax law, it's all of that, right? So statute law imposes, so you have a statute, right, that imposes an obligation. Wow. Which is mandatory, not voluntary. Oh, really? So what does the word mandatory means then? But not voluntary. Okay. The contents of your letter hold no valid legal basis. You do tell. I note that you are current employed by S&S Constructing Services UK Limited. I have sent them and you the appropriate tax code which will determine the correct amount of tax you pay on your salary. You have, if you have any follow-up questions, please contact me. My direct dial number is, or you can reply to the above email address. Yours sincerely, Tudor Davies, Complaint Investigation Manager. official. The information in this email and any attachments is confidential and may be subject to legal professional privilege. Unless you are intended the recipe of his her representative, you are not authorized to and must not read, copy, distribute, use, or retain this message or any part of it. If you are not the intended recipient, please notify the sender immediately. Blah, 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 blah. Okay. So, as you can see, on the 21st of June of 2021, Mr. Tudor Davies received the first communication from Adrian to his amazing claims that he made on that email. And we start to going by the following. All correspondence will be kept on file pending future legal proceedings. So now we thank Tudor Davies for his correspondence dated the 9th day of June of 2021. We have noted that there are claims being made and that Tudor Davies, in the position of complaints investigation manager for HM Revenue and Customs, is the claimant. So therefore, and let's go and remember the claims that we were seeing in the previous slides. So we have noted that there is a claim that there are UK tax laws, right? Well, if there is, we would like very much to see, right? We also have noted a claim, your obligations as a taxpayer. Wow, the taxpayer has obligations. Well, we would like to see that as well, wouldn't we? We have noted a claim being made under the Tax Management Act of 1970. Yes, because we noted that claim, right? We have noted a claim of first-hand knowledge that Mr. Adrian James is legally liable and culpable. Yeah, so Mr. Tudor has first-hand knowledge that Mr. Adrian James is legally liable and culpable. We have also noted a claim that no contractual agreements needs to exist between HMRC Revenue Customs and yourself in order for you to be liable to pay income tax. Well, we would like to see that as a presentable material evidence as well. We have noted a claim that, here we go, statute law imposes an obligation which is mandatory. So the statute law imposes that obligation. Yeah, we are all living in la la land, aren't we? We also noted a claim, the contents of your letter hold no valid legal basis. Oh, but yours does, right? Well, we would like to see that as well. We have noted a claim that Mr. Adrian James is legally liable to a tax code which has been sent by Tudor Davies to my employer, and by this means the correct amount of tax will be determined. So we would like to also see this tax code has creating that legal liability. We have noted that the correspondence sent to Mr. Adrian James has not been signed by an embodied hand, and we have noted that there is a claim of a complaint, right? Well, then let's go and have a look at that, okay? So here we are starting to show what is and what is not, okay? So we can only refer to the Companies Act 2006-44, execution of documents, Okay, this is their own jibber jabber against them because they don't do any of it, and they always have an excuse for anything, basically. So, but accordingly to the Companies Act 2006, Section 44 states the following. Under the law of England and Wales or Northern Ireland, a document is executed by a company, A, by the affixing of its common seal, or B, by signature in accordance with the following provisions. 2. A document is validly executed by a company if it is signed on behalf of the company, A, by 2 authorized signatures, or B, by a director of the company in the presence of a witness who attests the signature. And 4. A document signed in accordance with subsection 2 and expressed in whatever words to be executed by the company has the same effect as if executed under the common seal of the company. So, the legal effect of the statute is that documents and deeds must be signed on behalf of the company by a director in the presence of a witness, or by 2 authorized signatories. Without adherence to these provisions, no contracts can be considered duly executed by a company, and their terms are therefore legally unenforceable, as was clearly implied when the Court of Appeal endorsed the view of Lewis J. in the case of William versus Bradcard Limited in 2011. So for a document to be executed by a company, it must either bear the company's seal or it must comply with Section 44 in order to take effect as if it had been executed under seal. Subsection 4 requires that the document must not only be made on behalf of the company by complying with one of the 2 alternative requirements for signature in Section 42, paragraph 2, it must also be expressed in whatever words to be executed by a company. That means that the document must purport to have been signed by persons held out as authorized signatories and held out to be signing on the company's behalf. So here you have it. You guys can go and search all of this because this is in their website, and you can go and look it for yourselves. Okay, we are going to move along. So it is therefore indisputable conclusive that the correspondence unsigned by an embodied end is indisputable forensic material evidence of criminal fraud by abuse of position by the absence of recognized legal signatories. This can be seen, Exhibit C, the definition of the state by Chandras Kakutas, PhD of the London School of Economics. And here is the link. A state is a company no different to McDonald's, and the 2003 changes and the new responsibilities given to the Lord Chief Justice necessitated a certain amount of re-examination of the relationship between the judiciary and the 2 strong branches of the state, the executive and the legislature. This is all HM Parliament and government, formal and official. So here we are going to make them know about this amazing maxim. We would note here formally that there is a maxim that she who makes a claim also carries the obligation to provide the presentable material substance of the claim. We also formally note that where there is a claim without any credible presentable material substance to support that claim, then the claim is fraudulent in nature, which is fraud by misrepresentation and a non-criminal offense. Therefore, there is a clear and noted obligation of service for Tudor Davis, the claimant, in the position of complaints investigation manager for HM Revenues and Customers, to provide the valid, presentable material evidence to support the claims being made. That's pretty much clear. So we are going to pick up the claims and we are going to request the material evidence for each of those claims. So we have noted that there is a claim that there is UK tax laws. Therefore, there is a clear and noted obligation carried by Tudor Davis, the claimant, in the position of yada yada, to provide the valid and presentable material evidence to support such claim. I mean, you cannot just throw things at me and expect me to just believe in what you are writing. Okay, I need to read the same things that you read. I need to grasp where are you coming from with that UK tax laws. Okay, and we need to make certain that each one of us is correct in their statement. So nothing more than for you to be able to provide me with that material evidence, right? So we have noted that there is a claim of an obligation carried by Mr. Adrian James, and that this obligation deems Mr. Adrian James legally liable to pay income tax. Therefore, there is a clear and noted obligation carried by Mr. Yada Yada to provide the material presentable evidence of a contract, an agreement, or an arrangement between Mr. Adrian James and HR Revenues, where there can be an obligation to perform, right? Because the word obligation, exists. It cannot exist outside of a contract. Because if there is an obligation, there is an obligation for you to perform, to act upon, because you, like when you have your contract, right? Your contract states every single thing that you need to be doing. Like you need to come at 8 o'clock, you will go out for lunch at 1. If you get 15 minutes late, you will be it will be taken from your salary, this amount. You have only 15 days in a year for holidays. All of this, it's in your contract, right? So you have an obligation to perform under that contract. So that's what your obligation arises from. Okay, so but for HMRC to tell you that you have an obligation to perform without providing nothing apart from, oh yeah, you have to. Oh yeah, everybody has. Oh, because you are a taxpayer. Oh yeah, because you reside in here. No. I mean, no. Let's do things properly, shall we? Okay, moving along. We have noted that this claim being made under the Tax Management Act of 1970. Therefore, there is a clear and noted obligation of service carried by Mr. Yada Yada in the position of HMRC to provide the material and presentable evidence of the consent of the government agreements. Okay, my friends, why is that? Because this is the claim, okay, the Tax Management Act. So if there is a Tax Management Act, so it must be that there is material evidence of the consent, right, of the consent of the government, of their agreements, which should include a valid and legal signed consent to be governed agreement of Mr. Adrian James. Without this signed in full knowledge agreements, without coercion or deception of any kind, any action to enforce an act or legislative rule is illegal and is also a belligerent act of terrorism. Okay, this is what we are going against. Okay, all of it belligerent acts of terrorism on all of us in every scale. Okay, so we have also first-hand knowledge, right? Therefore, there is a clear and noted obligation of service to perform by Mr. Tudor, the claimant in the position of manager for HMRC, to Mr. Adrian James by providing the presentable and material evidence to support the claim that Mr. Adrian James is legally liable and obligated to income tax deductions. Yes. Yes, yes, yes. Let's bring all of that, Mr. Tudor. Right? You must have all of this. I mean, really? For you to make those claims, you must know this for a fact, right? You have all of this. You've been looking into them, and you decided to write that email because you have your certainty. It's not a belief, mine is a belief, but yours is not, because you must have looked into this, right? Don't think so. So we have noted a claim that no contractual agreement needs to exist between blah, 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 and yourself in order for you to be liable to pay income tax. Wow. Therefore, there is a clear and noted obligation carried by Mr. Tudor in the position of a manager for whatever to provide the presentable and material evidence to support such claim. Must be easy, right? This one is easy, yeah? So we have noted also a claim that statute law imposes an obligation which is mandatory. So good. Therefore, there is a clear noted obligation for Mr. To perform. Therefore, there is a clear, let me just highlight this. There is a clear noted obligation of service to perform to Mr. Adrian James by Mr. Tudor Davies in the position of HMR and Customs to provide the presentable material of evidence to support such claim, right? So Tudor Davies, you will at some point, here it is, you will at some point in your life have signed a consent form at the doctor's or the dentist. This signed document is the material evidence that you have given your consent to the doctor or the dentist. It is a maxim that he who brings the claim must also provide the material evidence that will support that claim. Without this material evidence presented as fact, then the moon is made from cream cheese because Bill and Ben said so, or Tudor David said so. A term of government is 4 years. There is a requirement for the signing of the consent of the government, every 4 years. Tudor Davies, when did you sign the consent of the governed on and for the public record? With full knowledge and understanding, without coercion or deception, and with full disclosure and transparency? Any of you? Anyone? Do you remember that day? Must be a big day with, fireworks and everything? No, don't think so. Yeah. So full disclosure means exactly that, disclosure to the fullest. So answer us this. How many paper clips do the Ministry of Defense have in Afghanistan? This might seem a mute point to make, but without the full disclosure, then your contract of employment is void from the start. The consent of the governed is a mandatory requirement before the legislative rule can be given force. The consent of the governed is a mandatory requirement before the legislative rule can be legally acted upon. Any action taken to enforce the legislative rule is illegal and a criminal action without the consent of the governed. Without the consent of the governed, there is no governed and no government by default. The one cannot exist without the other. And that's just that. Okay, those are facts. We have noted that there is a claim that the contents of your letter hold no valid legal basis. Well, Mr. Tudor Davies, for in the position of manager for HMRC, therefore has an obligation of service to provide the presentable and material evidence to Mr. Adrian James to support such claim. We have noted that there is a claim that Mr. Adrian James is legally liable to a tax code. Therefore, it is a clear notice obligation carried by Mr. Tudor, blah, 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 to provide the presentable and material evidence to support such claim. We also have noted a claim. I note you are a current employed of yada, 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 and I will send the tax code to your blah, 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 da-da-da, da-da-da. So Mr. Tudor David's in the position of manager, revenue and customs, whatever, therefore has an obligation of service to Mr. Adrian James by providing the material and presentable evidence to support this claim that Tudor Davids has a valid and legal ability to apply a tax code to the salary of Mr. Adrian James and carries the necessary legal authority to instruct the employer of Mr. Adrian James to make deductions. We have noted there is a claim of a complaint. Mr. Tudor, in the position of manager, therefore has an obligation to provide the presentable and material evidence to support such a claim. Yeah, because this is not a complaint at all. There has been no formal complaint, Mr. Tudor David. There is a clear instruction to cease stealing absent my legally required consent. Further legal action will be taken where any instruction by yourself to my employer results in illegal deductions. We do not complain. Children complain. We have also noted the contempt of court restrictions, the civil contempt. Civil contempt refers to conduct which is not in itself a crime, but which is punishable by the court in order to ensure that its orders are observed. Civil contempt is usually raised by one of the parties to the proceedings. Although the penalty for a civil contempt contains a punitive element, its primary purpose is coercion of compliance. Yes, it is. We would further note that the use of force in a civil matter is a willful and belligerent act of terrorism, and that the above contempt of court reporting restrictions prevent a judge from holding Mr. Adrian James in contempt in a civil matter. We have noted that there is a claim that an unsigned correspondence is a valid and legal executed document. Therefore, there is a clear notice obligation of service carried by Mr. Tudor in the position of manager, blah, 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 to provide the valid, presentable material evidence to support such claim. So far we are asking for Mr. Tudor to provide the material evidence to cooperate to the claims that he made on that email. Of course, we will give him 7 days to be able to gather all of that, because if he wrote that email, he must have the material evidence at hand. So it won't be something very hard to do, because he looked into it. He didn't just write an email. He didn't just do copy paste, you had to go and look, because it's an individual process, and we need to make sure that each one of, unless we don't, right? Unless we, oh yeah, you were born and this will apply to you, either you like it or not. Well, let's see if that is the case. Yeah, we will have the remedy immediately, right? So after the 7 days, if there is a failure to provide the valid and presentable material evidence to support the above listed claims made by Tudor Davies in the position of yada yada, in the next 7 days, will enter Tudor Davies in the position of complaints investigation manager into a lasting tacit agreement through acquiesce to the following effect. Okay, so this is very important, guys. Why? Because we give them the opportunity to bring and to shut us down, basically. You know, like, I'm not just spewing words here and writing them. I know for a fact, because I'm a manager at HMRC, so I know my shit, you know. So we are giving them the opportunity to bring your evidence to the equation. Okay, do not just make a claim that mine are just beliefs and you are not going to accept it, because it's a reflection, isn't it? Are you just saying that because that's what you are following, right? So let's see what is going on here. Okay, and if after the 7 days there is nothing you can bring to the table, so we have an agreement. And we are going to establish that agreement immediately, right? So that there is let me highlight this one, that there is now a formal agreement that a claim being made by Tudor Davies in the position of complaints investigation manager for HMRC revenue, that there is a valid and legal UK tax laws for which Mr Adrian James is legally liable and culpable, is fraudulent in nature, which is also willful and premeditated fraud by misrepresentation, which carries a term of incarceration of 7 to 10 years, and the later, where there is multiple instance of or has agreed to be bound and culpable for commercial charges to the same degree, and that there is a formal agreement between Tudor Davies in the position of complaints investigation manager for HMRC and Mr Adrian James, that Tudor Davies has formally agreed to the commercial charges to the same degree. Okay, so here we are already creating this lasting tacit agreement through acquiescence. Okay, so we are going to do this for all the claims that he will not be able to provide the material evidence of the claims that we listed above. And we make sure that they are all here, and we are very clear and very transparent on what we want to achieve with what we are doing. So there is no obfuscation, there is no hidden things going on. You know, we are as most transparent as we can be, a thing that they don't understand what it is. Okay, so after we listed all the claims and laying them down to create that tacit agreement, we will make them aware that they're under the same cover as this correspondence. There is enclosed the affidavit of truth and statement of fact, which has been served upon the Secretary of State and Secretary of the Crown as of the 20th day of February 2015, and all the MP's office of March 2015, and again on the 10th day of March 2020, which stands as uncontested, documented foundation in fact, on and for The record, it has most recently been served upon all members of the Welsh Assembly and every chief constable, and there is an agreement between Mr. Adrian James and each member of the Senate to the facts contained within the Adrian of the House of James Affidavit of Truth and Statement of Facts. A security by way of a lien has been perfected by its publication. And then securities by way of a lien, which was previously sent to you, to their Davids, are linked below. So this are some of the links if he cares to go and have a look. The same listed on and for the public record, you will also find it here in this entirely. So we await your response, and again, silence gives consent, and silence creates the agreement. So if you don't send nothing in the next 7 days, we already have your response. Again, this is what we call no obfuscation whatsoever. Okay, so they don't tell us this. That's why people are so confused, because they receive this or that and they think, oh, but I entered into an agreement, or no, you didn't, because it wasn't stated. Okay, so every matter needs to be laid out in full disclosure for you to be aware of it, because if there is any type of obfuscation, excuse me, if there is any type of obfuscation, I mean, how will you know? Okay, you can't know. So without ill will or vexation, for and on behalf of the principal legal embodiment, Adrian James. Okay, so 7 days have went through. Okay, now we are on the 30th day of June of 2021, and we are going to put some people into the equation, which is Jim Ara, Tudor Davids, the claimant, and whole member Provincial Field Marshal Walker of Aldringham. Okay, so we have noted that there has been no formal legally required response to our previous correspondence dated the 21st day of June of 2021. In the interest of candor, we have elected to extend the deadline by further 7 days. In the interest of clarity, we repeat the same here without ill will or vexation. Okay, so 7 days have passed. Maybe Tudor was a little bit he didn't know, he misplaced all his evidence and now he's trying to gather. So we decided, we are going to give you further 7 days, because we understand people can get a little bit lost in finding the UK tax laws. It must be very hard to find the Tax Management Act 1970 that applies to everyone. It must be very hard to find the this one, that there is no contractual agreement, but there is still an obligation to perform. We understand all that, right? So we're going to give you 7 days more. And with that in mind, so we repeat the same. So basically, this is what we are doing. We are stating again for him not to, get lost in the woods. No, we are giving you a map so you don't lose yourself. Here it is. All of the things that you need to provide. You have 7 days more. Don't get too comfortable. Maybe get to work, and bring us all that evidence. So at this point, we are 14 days in, right? And there is no response in between. So by this time, we are on the 9th of July. Hang on a minute. Let me just sip a little bit of coffee because my throat is requiring. Okay, so again, we are going to note that we are being ignored, and there has been no formal legally required response to our previous correspondence dated the 21st of June 2021 and the 30th day of June of 2021. But again, in the interest of candor, we have elected to extend the deadline by further 7 days. I mean, you had 14 days. Probably you are gathering your legal team, to give you some help on, I need to bring all this evidence to this lad here that is requiring me. I know I have this, that this must be the tutor's conversation, I know I have this somewhere. I know I can prove what I've written, unless I don't. And unless, that's why I'm taking that vote of silence. Unless there is no UK tax laws, unless there is no Tax Management Act of 1970 that can really apply to anyone, unless there is the consent of the government. Unless this guy here, Adrian James, just touched a point where we are all being observed, and things are getting a little bit complicated to our side. So we must go through our other resources, which is enforce things and create some fear in the mixture, like some spurges of fear. Maybe he will back away and leave us alone. I think this is what Tudor Davids must be thinking. I don't know. So again, we decided to go, for candor, give him a little bit of space to have another 7 days to go and gather all those things. And we just, send him again, hey, monkey boy, how about my material evidence of your claims? How can we move forward if, there is only you saying one thing while I am providing you with material evidence in each correspondence that I sent? We got to the end, right? And this is where the 21 days have passed, and there is no material evidence to be seen anywhere. Okay, so Tudor Davies just, I don't know, either he fell asleep or he just recognized that he was just disputing his beliefs because he had no way to provide the material evidence. But we will not let that go away, and we need to make sure that other people that are reading this case will know how we can tackle every situation in bringing the matter to the public records. Okay, so on the second part, you will get to the Exhibit B, an opportunity to resolve and a notice of default. So after the 7 days, so on the 21st of July of 2021, this is where we are going to make a few things more clearer to Tudor Davies. So we have noted that there has been no formal legally required response to our previous correspondence dated the 21st day of June and the 30th day of June of 2021 and the 9th day of July, respectively. And that there is now a formal agreement that the absence of any valid legal material evidence, I mean, that was from the first 7 days, okay? But we will, we are showing that we are not being provocative. We are giving him 7 days and another 7 days and another 7 days, because we understand the things can be like complicated to bring forward. But I mean, 3 times, and you didn't provide any material evidence? No, I don't think so. If there is a crime to be redressed, then it is important to comprehend the full extent of the crime before a solution or a remedy can be executed. You, Mr. Tudor Davis, have already been instrumental in this remedy, as you have provided vital material evidence which is a part of the solution or remedy. For this material evidence, we thank you. This might not be evident at first, but the solution or remedy will benefit all, including yourself. Complex matters have complex solutions. We can assure you that this solution is complex and that these complexities may not be comprehended at first. So, in interest of candor and clarity, again, we would note here formally that there is a maxim that she who makes a claim also carries the obligation to provide the presentable material substance of the claim. We also formally note that where there is a claim without any credible, presentable material substance to support that claim, then the claim is fraudulent in nature, which is fraud by misrepresentation and a known criminal offense. Therefore, there is a clear noted obligation of service for Tudor in the position of yada 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 to provide the valid and presentable material evidence to support the claims being made. So here we go again. We will state all of them again, the same thing we did before, right? We are going to ask, we are going to show him what we've been asking to be provided, 3 times, 7 days apart, and nothing. Okay, nothing whatsoever came from that. So, because nothing came from that, we have already an agreement, and that agreement is for acquiescence. Okay, and all the claims are here listed that he is a criminal by his own end, right? So here we have it. We continue to go along and state all of those claims that we pointed out in the beginning, okay? So, these are very serious crimes, Mr. Tudor Davis, and under current state legislation, there is a cumulative period of incarceration in excess of 32 years. We would not wish to encumber the public purse of the costs of this incarceration, as the public purse can ill afford this financial encumbrance. There is, however, an alternative and recognized process as suitable remedy. As there is now an agreement between the parties by way of lasting tacit agreement through acquiescence, and as you have already agreed to the crime, then we elect to charge you under this agreement. As the crime was committed against ourselves, then we deserve the right to choose the remedy for these crimes. Where there is a crime, then there is a requirement for a remedy, otherwise the crime goes unresolved. And as we now have an obligation to bring this crime to resolution, we therefore are giving you an opportunity to resolve. Okay, so we are going to be gentle with you, as you guys are gentle with us, so let's see how does that thing work, right? So here we are. For the first formally agreed criminal offense of fraud by misrepresentation, where the claim being made by Tudor Davis that there is a valid and legal UK tax laws is fraudulent in nature, which is also willful and premeditated fraud by misrepresentation. Where this is an agreed chargeable criminal offense, then we will elect to formally charge Tudor Davis in the position of complaints investigation manager for HMRC £5 million. Yeah, why the £5 million? Well, you could charge him £1,000. You can charge him £10, but It's nothing, for the people that already know and comes from the affidavit, this is £5 million of faith and belief. Okay, same thing that they tell us that you need to pay this or that. Well, it's just this, numbers on a paper. And so this was a rounded number. There is no where did this number came from? Well, it came from the same source that all numbers came from, out of thin air. How money is created? Out of the blue. It's the same thing here. Okay, so there is obviously I think I would like to point out, do not go wild in this. Just make it accessible in a way that is good for the eyes. And I think the number 5 is always a good, it's, you see, it's in there, it's in the middle, so yeah, be gentle with that. So we go on and state that for the first formally agreed criminal offense of malfeasance, here we are going to go after the malfeasance, where Tudor Davis in the position of investigation, blah, 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 where this is an agreed chargeable criminal offense, then we elect to formally charge in the position, again, £5 million for the malfeasance. And we are going to go for the second formally agreed criminal offense of fraud of misrepresentation. Just for the first malfeasance. Yeah. And for the second formally agreed offense of fraud by misrepresentation, where Mr. Tudor Davis, that Mr. Adrian legally liable to pay income tax, is fraudulent in nature, which is also a willful and premeditated fraud by misrepresentation. We where this is an agreed chargeable criminal offense, then we will elect to charge again £5 million. And for the second, again, we are going after for the malfeasance. Here we have again for the Management Act. So each one of them, we are going to charge this one, and for the malfeasance, for the claimant itself, and then the malfeasance perpetuated. So this is pretty much how it will go. And then we will have, we will have here the malfeasance, and then we will make a final charge, which is this one for the formally agreed willful and premeditated act of terrorism, which is a recognized criminal offense where there is an agreed chargeable criminal offense. Then we will elect to charge Stephen House in the position of complaint manager £5 million. Pounds. Did I? Okay. So we elect to charge Tudor Davis, £5 million, exactly. So the total agreed debt as a resolution for the above criminal offences equals £75 million. So this is what, please make remedy by way of commercial instruments or personal check to the above address. If this is by personal check, then please make the check in the name of Adrian James. If you, Tudor Davis, elect not to resolve this matter, and that in the next 7 days from the receipt of this correspondence, then 7 days later we will issue a further reminder that you, Tudor, are in default of your agreement. And that's what we will do for sure. So We are going to state the obvious here. This may be viewed to be an excessive action to take as a remedy, but we bring your attention back to the affidavit, Exhibit F. Nobody gets paid, so this is an excessive action where there is no monetary value. No injury, loss, or harm can be caused by the action. This is just numbers of no commercial significance, as there cannot be commerce without money, and there is no such thing as money, so there is no such thing as economics. It is not our intent to place you, Tudor Davids, in a state of distress or cause any distress, loss, or harm by this legal action. Let us face the fact. See Exhibit F in the affidavit. There is no such thing as money. The Bank of England note is based upon confidence and belief, where belief is a concept in the abstract, which is of no material substance. So to the Davis, we have expressed the criminal offences, and there is an obligation to resolve. We have also noted that the others in association are also complicit in the same criminal offences. He who is complicit in any crime offences also carries the obligation to bring those also complicit in the same criminal offences to resolution. It could be said that to take this action is to destabilize the economy. What economy? That was done generations ago when the government licensed fraudulent banking practice. By that we mean Federal Reserve banking practices, fractional lending, and quantitative easing. We did ask ourselves, are we committing fraud? Our response to this was, is there full disclosure? Yes. Is there an agreement between the parties as a result of that disclosure? Yes. Is there any injury, loss, or harm? No. Then there is no fraud. Okay. Are we destabilizing the government without the consent of the government? On and for the record, then there is no govern and no government by default. What government? See Exhibit under the affidavit, Exhibit H. Without a valid and accountable government, then there is no such thing as a public or the public purse. So, Tudor Davis, you have now again 7 days to make reparation for your criminal offences. 7 days after, then there will be a notice of default, and 7 days after, there will be a security by way of a lien. We will draw your attention, excuse me, you would draw your attention to the recent perfected and published liens undertaken against the officers of the government. You can see them there, or the supposed cold government. So again, we await your response. Again, silence gives consent, and silence creates the agreement. So 7 days have gone, and on the 8th day of July, here we go again, do the same thing to them as they do to us. So there is a notice of default, non-negotiable. Important legal information, do not ignore. So we have tacit agreement by acquiescence dated the 9th day of July, and opportunity to resolve dated the 21st day of July. Tudor Davids, this letter is a notice to you that you are now in default of your obligations under the above written tacit agreement by acquiescence as a result of your failure to make remedy by way of a commercial instrument. I hereby declare, as of the above date, Tudor Davids is now in default. So that there can be no confusion, this notice is lawfully executed as of the above date. If, however, you, Tudor Davis, makes remedy by way of a commercial instrument within the next 7 days, the notice of default will not be entered against you, Tudor Davis. For the avoidance of doubt, failure to make the remedy by way of commercial instrument to this demand and default notice dated the 20th day of July within the 7 days allow time frame, we will enforce the notice of default in its entirety. This is the only words we use here. We will enforce. You will see what we mean by that. There is no force used, because otherwise we will be terrorists, okay? And we are not terrorists by far. We are not like them. Further legal action will be taken to recover the outstanding debt. Legal proceedings will be taken to resolve this matter by raising a security by way of a lien. We await your response, and silence gives consent, and silence gives the agreement. And again, we did what we had to do. Yeah, and now we go back to closing this matter. So when this matter is closed, this is where we raise the security by way of a lien. So this is what we are enforcing, okay? So there is a security by way of lien created. There is a lien already on Tudor Davies. And let's see. So here on the 12th day of August of 2021, we have noted as of this day, the 12th day of August 2021, that there has been no response to our previous correspondence. And to that effect, there is a formal and binding agreement to the following. Security by way of a lien. And here we're going to start with our affidavit of truth and statement of facts. So I, Baron of the House of James, that I'm competent to state the matters herein, that I am herein stating the truth, the whole truth, and nothing but the truth, and that this truth stand as fact till another can provide the material, physical, and tangible evidence and substance to the contrary. That I fully, completely comprehend that there, before any charges can be brought, it must be first proved by presenting the material, physical, and tangible evidence and substance to support the facts, that the charges are valid and have substance that can be shown to have any foundation in fact, that I have first-hand knowledge to the fact stated herein, that the eternal unchanged principles of truth are as follows. All are equal and free by natural descent. Truth is factual and not subject to belief, which is nothing of material, physical, or tangible substance in fact. An unrebutted affidavit stands as truth and fact. An unrebutted affidavit is the documented fact and truth on and for the record. All matters must be expressed to be resolved. He who does not rebut the affidavit agrees to it by default. He who does anything by another's hand is culpable for the actions of the other's hand. A security by way of a lien is, first and foremost, an agreement between the parties, and as there is no disagreement between the parties, that he who stands as surety by providing the security by way of a lien stands in honor, as that surety is undertaken by agreement without coercion, duress, or protest, without the threat of harm, loss, or injury, and as such stands in honor for that harm, loss, or injury by their own hands. So with this, we go by making our affidavit of truth and statement of facts relating to this matter. It is now on and for the record, as of the 12th day of August, that this is a formal agreement between Baron David James and Mr. Tudor Davies in the position of yada yada. That Mr. Tudor Davies in the position of Complaints Investigation Manager has agreed to stand as surety for a security by way of a lien for the restoration for the criminal offences of fraud and malfeasance in the office of HMRC. Let it also be noted here and for the record and in perpetuity that Mr. Davies in the position of Complaints Investigation Manager at any time presented any valid presentable material evidence to his claims that there is a valid and legal UK tax laws. The claims are made under an Act of Parliament. Act statutes are clearly not law, but policy of a private for-profit corporation. Let it also be noted on and for the record and in perpetuity that Mr. Tudor Davies has never at any time presented any valid presentable material evidence to his claims that Mr. Adrian James is legally liable to a tax code. Let it also be noted on and for the record and in perpetuity that Mr. Tudor Davids in the position, blah, 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 has never at any time presented any valid and presentable material evidence that Mr. Adrian James is legally liable and culpable under these alleged UK tax laws. Let it also be noted and for the record that Mr. Tudor Davies has never at any time presented any valid and presentable material evidence to support his claims that Mr. Adrian James is legally liable to pay income tax. Let it also be noted on and for the record that Mr. Tudor Davids has never at any time presented any valid and presentable material evidence to his claims that Mr. Adrian James carries a legal obligation under the Tax Management Act. Let it also be noted on for the record that Mr. Tudor Davids has never at any time presented any valid presentable material evidence to support his claims that he has any first-hand knowledge in this matter whatsoever. Let it also noted on the record and in perpetuity that Tudor Davids has never at any time presented any valid presentable material evidence to support this claim. No contractual agreement needs to exist between yada, yada, yada. And let it also be noted on and for the record that Mr. Tudor Davies has never at any time presented any valid presentable material evidence to the claim. Statute law imposes an obligation which is mandatory. And let it also be noted on and for the record that Mr. Tudor Davies has never, ever at any time presented any material evidence to this claim, thus the content of your letter holds no valid legal basis. So we go on in making all this to be on and for the records, which we can clearly see that there is a problem here with Mr. Tudor Davies, because they can think that they can write everything, and we just go on and oh my God, I'm so scared, and what they are saying has any validity or any authority. I mean, the thing here is you need to ask questions, that's where you need to start. You need to start making questions. Don't accept just what they tell you as truth, you need to seek for your own truth. You need to ask your own questions. You need to make sure that everything is done appropriately, it's not just like because he's going to tell you something and you are going to accept it immediately because they are saying so. Do you know what I mean? So, I think I'm going to leave this one at that. It's been a little bit long. Next time I will bring a letter to cease and desist to the HMRC. So we will do a follow-up on this segment as well. And I hope this one was very enlightening to you guys. And I hope you were able to catch how to go about with picking up their claims and asking your questions. So it's all for now. See you when I see you, and have a good one. Bye-bye.